All right, and then I'm going to start the broadcast. Well, somebody's trying to get in. Reader AI. No. Okay, here we go. All right, it is March 31st, and tonight is the last volume of the Foundations and Risk Literacy series. We're going to go over Private Process Myths, Volume 7, Why Popular Claims Fail in the Real World. And if you do like the material that we are giving every week, please remember to subscribe, like, and share, and join our website at www.privatepathhrsolutions.com and get ready, because starting next week on the 7th, we are going to be starting our Family Office series. All right, here we go. Important notice, scope and intended use. This ebook is part of the Private Foundations and Risk Literacy series. The live YouTube sessions associated with this series are provided for general educational literacy only and are designed to help viewers understand administrative systems, terminology, and common sources of confusion. This ebook goes beyond the scope of the live sessions. It contains structured analysis, sequencing explanations, and reference material that is not presented publicly, and it is intended solely for members who have agreed to the Private Membership Association terms. This material does not provide legal advice, tax advice, or instructions for filing. It is designed to support informed decision-making and to reduce harm caused by misunderstanding administrative processes. Private membership use only. Access to this ebook is limited to members of the Private Path Membership Association who have completed the membership application, agreed to the association agreement, and executed the non-disclosure agreement. Redistribution, excerpting, or use of this material outside the PMA is prohibited. This restriction exists to ensure that the material is studied in its proper context and is not misapplied, misquoted, or used without adequate foundational understanding. The YouTube series teaches literacy. The ebook exists so students don't misapply what they learn. Private Membership Association Notice. This publication is a private education resource made available exclusively to members of the PMA. Access to this material is conditioned upon acceptance of the PMA membership agreement and NDA. Use of this publication is limited to personal educational study by authorized members. Unauthorized sharing, reproduction, distribution, or commercial use of this material, whether in whole or in part, constitutes a breach of private contract and may result in remedies available under the PMA agreement, including termination of membership and pursuit of contractual or civil relief where appropriate. Disclaimer and educational notice. This ebook is provided for educational and informational purposes only. It does not constitute legal, tax, or financial advice, and it should not be relied upon as such. The material in this publication is based on private research, historical references, and educational analysis, including concepts taught by Patrick Devine as interpreted and expanded upon by Private Path HR Solutions. The purpose of this work is to explain administrative classification, presumptions, and common sources of misunderstanding, not to instruct readers on filing, compliance avoidance, or legal strategy. Readers are solely responsible for their own decisions, actions, filings, and outcomes. No guarantees, express or implied, are made regarding results. For matters requiring professional judgment, readers are encouraged to consult a qualified licensed professional in the appropriate jurisdiction. Copyright and use restrictions. Copyright 2025, Private Path HR Solutions PMA, all rights reserved. No part of this publication may be reproduced, stored, transmitted, or distributed in any form or by any means without prior written permission, except for brief quotations used for private study or commentary within the PMA. References to government agencies, including the Internal Revenue Service, are descriptive and educational only. Nothing in this publication instructs or encourages evasion of lawful reporting or compliance obligations. Contact us. If you have questions, need guidance, or wish to access additional tools and consulting, contact us at www.privatepatHRsolutions.com or email privatepatHRsolutions@gmail.com. If you wish to be part of the classes, send us an email to classes@privatepatHRsolutions.com. Instagram or TikTok, you can find us at Private Path HR. And Private Path membership access is available through our website. Introduction. Why this volume exists. By the time learners reach the end of this literacy series, most have encountered a familiar frustration. They have studied systems carefully. They understand jurisdiction, structure, and limits, and yet they continue to hear bold claims repeated confidently, circulated widely, and presented as settled truth that contradict everything they have just learned. This volume exists to address that tension, not by arguing with claims one by one, and not by replacing them with counterclaims, but by examining the patterns that cause certain ideas to spread and then fail predictably in real-world settings. Private process myths do not persist because people are careless. They persist because they borrow legitimate language, detach it from structure, and promise relief from complexity. This volume restores that missing structure. The difference between questioning and myth-making. Questioning systems is healthy. Myth-making begins when questions are answered prematurely, when language substitutes for process, and when confidence replaces verification. At that point, explanations stop evolving and start repeating. This volume does not discourage inquiry, it sharpens it. Each chapter examines a commonly repeated claim and traces where it breaks, not emotionally, but structurally. The focus is not on whether something sounds right, but on whether it can survive contact with reality. Why pattern-based analysis matters. Naming individuals does not correct misunderstanding. Patterns do. When the same type of claim falls or fails in the same way across different contexts, the problem is not execution, it is assumption. Pattern-based analysis allows myths to dissolve without confrontation because the structure that supported them is no longer there. That is the approach taken here. How this volume fits the series. Volumes 4 through 6 focused on preventing harm caused by premature action, misinformation, and misapplied commercial process. Volume 7 completes the literacy foundation by addressing the narratives that remain once statutes and codes are no longer misunderstood. It removes the pressure to figure something out when nothing is actually there to resolve. This is not the end of learning. It is the end of chasing explanations that cannot hold. Chapter 1. Bills are prepaid and the illusion of settlement. Introduction. Few claims spread as easily as the idea that bills are already paid. It offers immediate relief from pressure. It reframes obligation as deception and transforms confusion into certainty. Once heard, it is difficult to ignore, especially when repeated with confidence and accompanied by fragments of financial language. This chapter exists to examine why that claim feels persuasive and why it consistently fails when applied in the real world. How the claim is usually presented. The bills are prepaid narrative typically appears in simple form. It suggests that utilities, taxes, credit cards, or other obligations have already been settled through hidden mechanisms. That payment occurs at a systemic level, often without the individual's awareness, and that the remaining bill is merely a request, not a demand. The explanation varies, but the structure is consistent. Money is said to move invisibly. Records are said to be concealed. Non-payment is reframed as correction rather than default. This framing replaces uncertainty with reassurance. Why the claim feels convincing. The appeal of the prepaid narrative does not come from evidence, it comes from emotional alignment. Bills are stressful. Payment systems are opaque. Institutions rarely explain processes clearly. In that environment, explanations that promise resolution without confrontation feel humane rather than deceptive. The claim also borrows legitimacy by echoing real concepts: clearing, settlement, offsets, and accounting entries. When those words are used without context, they sound authoritative, even when detached from the systems they belong to. Repetition does the rest. Where the structure breaks. Payment systems are observable. Bills do not exist in isolation. They are part of contractual, statutory, or service-based relationships that require measurable settlement. When payment occurs, records change. Balances update. Access is restored. Those effects are visible because they must be. The prepaid narrative fails because it produces none of those effects. No account reflects settlement. No ledger closes the obligation, and no system recognizes completion. Instead, silence is reinterpreted as a confirmation and continued billing framed as error or fraud. The absence of evidence becomes the proof. That inversion is the structural failure. Why repetition does not create settlement. One of the most persistent features of this myth is the belief that asserting payment forces recognition. But systems do not respond to assertion. They respond to reconciliation. Settlement occurs when value is transferred through recognized channels and recorded accordingly. Language alone cannot substitute for that process. Repeating a claim does not change balances, and insisting on belief does not alter accounting. Patrick Devine emphasized understanding how systems account for value. He did not teach that belief or declaration replaces settlement. The prepaid narrative emerged later, detached from that grounding. The consequences of acting on the claim. Acting as though bills are prepaid does not expose hidden payment. It exposes misunderstanding. Services are suspended, accounts are closed, penalties accrue. When challenged, the individual is often left without recourse because no evidence of settlement exists. The harm does not come from questioning the system. It comes from acting on an explanation that cannot produce results. This is why the claim fails predictably, not because it is suppressed, but because it cannot function. In closing, the idea that bills are prepaid persists because it answers emotional questions better than structural ones. It promises relief without requiring understanding. It reframes complexity as concealment. But when tested against reality, it produces no settlement, no closure, and no protection. This chapter does not ask you to accept obligation unquestioningly. It asks you to distinguish between explanation and effect. In the next chapter, we will examine another claim that follows a similar pattern, the misuse of OID and 1099 forms, and why repurposing reporting tools as remedies fails in the same way. For now, this distinction holds. Belief does not reconcile accounts. Structure does. Chapter 2, the misuse of OID and 1099 forms. Introduction. After the idea that bills are prepaid begins to unravel, another explanation often appears. This one sounds more technical. It invokes tax forms, reporting codes, and internal accounting language. It suggests that if income is being reported incorrectly, then correcting the report must correct the obligation itself. OID and 1099 forms are pulled into this role. This chapter exists to explain why that move feels logical and why it consistently fails. How the claim is usually framed. The misuse of OID and 1099 forms follows a familiar pattern. It begins with the observation that institutions report income to the IRS. From there, the assumption is made that reporting equals creation, that if something is reported as income, it must be income in substance. The next step is to reverse the report. By submitting alternative forms, the individual believes they can reclassify the transaction, offset balances, or force reconciliation through the tax system. The structure of the claim is simple. Reporting is treated as causation, correction is treated as settlement, and forms are treated as remedies. Why the theory sounds plausible. The tax system is opaque. Most people never see how information flows between institutions and the IRS. Forms appear authoritative. Codes look technical. And when something feels wrong, it is tempting to believe the error lies in classification rather than in obligation. OID, in particular, sounds arcane. It is rarely encountered directly by individuals, which makes it easy to mythologize. When paired with 1099 forms, documents many people recognize, the theory gains surface credibility. But surface credibility is not structure. Where the logic breaks. OID and 1099 forms are reporting instruments. They describe how income is characterized after a transaction has already occurred. They do not create the transaction, and they do not control its validity. Filing a form does not alter the underlying agreement, obligation, or balance. Reporting follows reality. It does not redefine it. When a form is submitted that does not correspond to an actual reporting obligation, the system does not reconcile accounts. It flags inconsistency. That flag does not produce settlement. It produces scrutiny. Why reclassification does not eliminate obligation. One of the core misunderstandings in this area is the belief that if income is misreported, then correcting the report cancels the debt. In reality, even when reporting errors exist, the obligation remains until it is satisfied through the mechanism that created it. Tax forms address taxation. They do not discharge contracts, loans, or service obligations. This is why attempts to use OID or 1099 filings as payment substitutes fails uniformly. No account balance changes, no service is restored, and no obligation is extinguished. The system responds exactly as designed. The pattern of consequence. People who attempt to use reporting forms as remedies often experience the same outcome. The filing is accepted administratively. Nothing else happens. When follow-up occurs, it is not recognition, it is inquiry. In some cases, penalties arise from improper or frivolous filings. In others, the filings are ignored entirely. The promised leverage never materializes. This is not because the forms are secret weapons that were misused. It is because they were never weapons at all. In closing, the OID and 1099 forms exist to describe income, not to create settlement. When they are treated as remedies, the result is confusion layered on top of obligation. The reporting system does not override the systems that created the debt, and it cannot be used to force outcomes it was never designed to produce. This chapter is not about discouraging questions. It is about recognizing when a tool belongs to explanation, not execution. In the next chapter, we will examine another narrative built on the same structure, claims about Treasury Direct accounts, and why personal access narratives fail the moment design is understood. For now, this principle holds. Reporting does not resolve reality, it reflects it. Chapter 3, the Treasury Direct Account Narratives. Introduction. After reporting forms fail to produce results, attention often shifts to accounts. Not ordinary accounts, but special ones. Accounts said to exist quietly in the background, accessible only through the right language or process. Treasury Direct frequently becomes the focal point of this narrative. This chapter exists to explain why those claims arise, what Treasury Direct actually is, and why personal account narratives collapse immediately when examined. How the claim is commonly presented. Treasury Direct is often described as a hidden repository. The narrative suggests that accounts are created automatically, tied to identity, and funded through government processes beyond public visibility. Access is said to be restricted not by eligibility, but by awareness. Once someone knows, the account can allegedly be activated. The claim usually carries an important implication. If money exists in the Treasury, then payment problems are artificial. That implication is powerful. Why the idea feels plausible. Treasury Direct sounds authoritative. It carries the weight of government finance, national debt, and securities issuance. Most people do not interact with it regularly, which makes it easy to imagine as opaque or inaccessible. When combined with prior exposure to myths about hidden value, the idea feels like a logical next step. Complexity is mistaken for concealment, but complexity does not imply personalization. What Treasury Direct actually is. Treasury Direct is a platform. It exists to allow eligible participants to purchase, hold, and manage specific U.S. Treasury securities directly without using a broker. It is transactional, opt-in, and tightly regulated. It does not auto-generate accounts. It does not assign funds by identity, and it does not operate invisibly. Every account is created intentionally, funded deliberately, and governed by published rules. Participation requires affirmative action and eligibility, not discovery. This design alone collapses most personal account narratives. Where the narrative breaks structurally. The Treasury Direct myth relies on substitution. Instead of identifying an actual issuance, it substitutes assumption. Instead of tracing a transaction, it assumes allocation. Instead of demonstrating entitlement, it relies on belief that value must exist somewhere unseen. But Treasury Direct does not function that way. No account activity appears without initiation. No balance exists without funding, and no access is granted without qualification. Silence is not concealment, it is absence. Why attempts to access hidden accounts fail? When people attempt to interact with Treasury Direct based on these narratives, nothing happens. There is no acknowledgement of hidden funds, no conversion of identity into access, and no recognition of entitlement. This outcome is often reframed as obstruction or denial. In reality, it is consistency. The system is behaving exactly as designed because the premise it is being asked to confirm does not exist. Patrick Devine did not teach Treasury Direct access as a personal remedy. His discussions of government finance were about literacy, not entitlement. In closing, Treasury Direct is not a vault of personal accounts. It is a platform for managing specific securities through defined processes. When this is understood, the personal account narrative dissolves without confrontation. This chapter does not argue against skepticism. It replaces speculation with structure. In the next chapter, we will examine another narrative built on administrative misunderstanding, the birth certificate monetization stories, and why administrative records are repeatedly mistaken for financial instruments. For now, the principle holds. Access follows transaction, not belief. Chapter 4, Birth Certificate Monetization Narratives. Introduction. Few narratives are as persistent or as emotionally charged as the idea that birth certificates are monetized. This claim often appears after exposure to other private process theories. It promises an explanation for why identity feels constrained, why institutions appear to track people so closely, and why financial systems seem indifferent to personal circumstances. By framing the birth certificate as a financial instrument, the narrative offers a single source for many frustrations. This chapter exists to examine why that story took hold and why it fails structurally. How the narrative is usually told. Birth certificate monetization stories follow a familiar arc. They suggest that registration at birth creates a financial asset, often described as a bond or security. That asset is said to be traded, pledged, or leveraged without the individual's consent. Over time, the narrative expands to include claims about capitalization, insurance pools, or global markets. The underlying message is consistent. Your identity has already been converted into value. You are excluded from it. Someone else benefits. This framing is powerful because it transforms administrative processes into moral injury. Why the story feels persuasive. Birth certificates are official. They involve registration, numbering, filing, and government custody. Those features resemble aspects of financial systems, which makes it easy to project financial meaning onto them. When combined with unfamiliarity about how markets actually work, the resemblance becomes assumption. Documentation is mistaken for capitalization. The story also fills an emotional gap. It explains why people feel tracked and managed from an early age, and it offers a reason for that experience that feels intentional rather than bureaucratic. What birth certificates actually are. A birth certificate is an administrative record. It documents a vital event for purposes of civil status, identity verification, and eligibility for rights and services. It does not represent an asset, an instrument, or a claim to value. No issuance occurs, no offering is made, and no market participation exists. Without those elements, securitization cannot occur. Governance. Financial instruments serve investment. Confusing the two creates a story, not a structure. Where the monetization theory breaks. The monetization narrative assumes that registration equals conversion. In reality, registration establishes status, not value. It enables recognition, not capitalization. No balance sheet exists because there is nothing to account for. If birth certificates were financial instruments, they would leave observable traces, issuance documents, market identifier and custodial records, and transactional history. None of these exist because the premise itself is incorrect. The absence is not concealment, it is confirmation. Why the narrative persists. The birth certificate monetization story persists because it answers why more satisfyingly than reality does. Bureaucracy is unsatisfying. Markets are complex. Identity systems feel impersonal. The narrative offers intention where there is process and design where there is administration. But emotional coherence is not structural coherence. Patrick Devine did not teach that birth certificates are securities. His emphasis was on understanding administrative systems clearly enough to stop attributing power where none exists. In closing, birth certificates are not bonds. They are records of status, not instruments of finance. When this distinction is understood, the narrative loses its hold, not through argument, but through clarity. This chapter does not deny that systems can feel invasive or impersonal. It clarifies that administrative functions should not be mistaken for financial exploitation. In the next chapter, we will examine why judges often dismiss certain filings immediately, not because they are hostile to questions, but because they recognize patterns that signal structural misunderstanding. For now, principle holds. Registration is not monetization, and records are not assets. Chapter 5. Why judges dismiss certain filings on site. Introduction. By the time a claim reaches a courtroom, most of the work has already been done. Judges do not encounter filings in isolation. They encounter patterns. Over time, certain language structures, document formats, and assertions become immediately recognizable, not because they are controversial, but because they consistently fail to align with law, procedure, or jurisdiction. This chapter exists to explain why some filings are dismissed almost immediately and why that outcome is not personal, punitive, or conspiratorial. Courts do not evaluate belief, they evaluate fit. Courts do not exist to resolve theories, they resolve disputes. For a filing to be considered, it must fit within a recognized legal framework. Jurisdiction must exist. Standing must be established. Causes of action must be cognizable, and relief sought must be something that the court can grant. When a filing does not meet those thresholds, it is not debated, it is dismissed. This is not hostility, it is filtration. The patterns judges recognize quickly. Certain features appear repeatedly in filings that are dismissed on site. They often rely on declarative language rather than causes of action. They cite statutes or codes without demonstrating applicability. They assert status rather than establishing standing. And they seek outcomes that no court has authority to provide. These patterns are not subtle. They signal misunderstanding before substance is ever reached. Judges are trained to recognize this early because addressing it later wastes and procedural integrity. Why volume alone does not create credibility. One common belief is that extensive documentation forces engagement. In reality, confusion. Lengthy filings filled with citations, definitions, and assertions can appear impressive, but without procedural alignment, they create noise rather than clarity. Courts are not persuaded by density. They are persuaded by relevance. More paper does not equal more standing. More language does not equal more authority. When filings confuse explanation with application, dismissal is the predictable outcome. Misinterpreting dismissal as suppression. When a filing is dismissed quickly, it is often interpreted as evidence that something threatening was said. This interpretation is understandable, but incorrect. Dismissal usually indicates that the court recognized the filing as non-justiciable. The content did not trigger review because it did not present a legal question the court could answer. There is no suppression where there is no jurisdiction. Patrick Devine warned against mistaking silence for resistance. Courts do not argue with filings that fall outside their scope. They simply move on. Why this chapter matters for safety. Understanding this pattern prevents escalation. People who misinterpret dismissal often respond by filing more, asserting harder, or broadening claims. Each step deepens the misunderstanding and increases exposure emotionally, procedurally, and sometimes financially. This volume exists to interrupt that cycle. Recognizing the pattern early allows learners to stop before consequences compound. In closing, judges dismiss certain filings on site because those filings reveal misunderstanding before argument ever begins. This is not judgment of intent, it is recognition of structure. When law is approached as language rather than framework, courts respond with silence or dismissal, not out of resistance, but out of alignment with their role. This final chapter completes the pattern analysis of this volume. With the most persistent private process myths addressed, the literacy foundation is now complete. What remains is not another explanation, but the skill of discernment, knowing when a claim cannot hold before time, energy, or risk is invested. That is the focus of the closing reflection. For now, this principle holds. Courts do not debate them. Discernment is the skill that remains. This volume does not exist to replace one set of explanations with another. It existed to end the cycle that makes explanations necessary in the first place. Across every chapter, the same pattern emerged. Claims sounded compelling because they borrowed legitimate language. They promised resolution because they removed complexity. And they persisted because they offered certainty where understanding takes time. But when each claim was placed back into structure, into observable systems, defined roles, and actual process, the outcome was the same. Nothing activated, nothing reconciled, and nothing changed. Not because something was hidden, but because nothing was there to function. This is the moment where literacy becomes discernment. What discernment actually is. Discernment is not skepticism. It is the ability to recognize when a claim cannot hold before testing it personally. It is knowing when language is being used as substitution rather than explanation. It is sensing when certainty is being offered to bypass structure. Discernment does not require confrontation. It does not require debunking. It does not require proving someone wrong. It requires noticing patterns. Once those patterns are seen, myths lose momentum on their own. Why this series had to end here. This literacy series could not end with a system. It had to end with a skill. Systems change. Narratives evolve. New terminology appears. But the pattern that produces myth remains the same. Language detaches from structure. Confidence detaches from authority, and urgency detaches from sequencing. If you can recognize that pattern, you no longer need to chase explanations. That is the safeguard this series was designed to provide. What this literacy series now protects. With this foundation in place, you are less likely to act prematurely, confuse form with authority, mistake repetition for proof, and escalate when silence appears, or substitute paperwork for position. More importantly, you are better equipped to pause when something sounds right but does not align. That pause is not hesitation, it is protection. The purpose of the literacy is not mastery of every system. It is knowing when not to engage. This series was never about withholding action. It was about ensuring that when action is appropriate, when role, authority, and structure truly exist, it is taken from clarity rather than from pressure. Nothing in this series asked you to abandon inquiry. It asked you to slow it down. And in that slowing, something important happens. Optionally, is preserved. Optionality is preserved. My apologies. That is the quiet outcome of discernment. And with that, the literacy foundation is complete. Where we go from here. The literacy series was never meant to turn readers into experts in filings, forms, or financial systems. It was designed to do something far more important, to slow people down before they made decisions that could not easily be undone. Most people enter this subject looking for solutions. They want to fix something, access something, correct something, or reclaim something. That urgency is understandable, but it is also the reason so many people make irreversible mistakes. They begin acting before they understand the environment they are acting in. This series was written to interrupt that pattern. By this point, you should understand something very important. Most of the problems people encounter in this phase do not come from lack of paperwork, lack of filings, or lack of secret knowledge. They come from acting without structure, without governance, without records, and without administrative discipline. People attempt to exercise authority they have never built, enforce rights they have never documented, and manage assets they have never organized. The result is predictable, not because systems are hiding something, but because administration requires structure, and structure cannot be replaced with documents alone. So the question now is not, what do I file next? What account do I access? What form do I send? Or what process do I try? The question now becomes, if anything is ever to be administered properly, what structure must exist first? That question leads to governance. Before trusts are operated, before fiduciary rules are exercised, before estates are administered, and before any form of enforcement or remedy is attempted, there must be an administrative structure that governs decisions, records, actions, maintains continuity, and separates roles and responsibilities. Without governance, everything becomes reactive. Records become incomplete, authority becomes unclear, and decisions become inconsistent. This is why the next phase after literacy is not remedy, not enforcement, and not banking. The next phase is administration and governance. This is where the concept of the family office becomes important. A family office is not a trust, and it is not a filing. It is the administrative environment where decisions are made, records are maintained, roles are defined, and oversight occurs. It is the place where governance exists before authority is exercised. It ensures that actions are documented, that responsibilities are clear, and that administration continues even when people change roles or circumstances change over time. Without governance, trusts become disorganized. Fiduciary roles become personal instead of administrative. Records become incomplete. Authority becomes situational, and structures collapse under pressure. With governance, decisions are recorded, roles are defined, records are consistent, risk is evaluated before action, and administration continues regardless of individual personalities or events. This is why the education path does not move from literacy directly into advanced processes. It moves from literacy into administration, then into trustee responsibility, then into fiduciary authority, and then into private operations and associations, and only after that into more advanced estate and administrative processes. The order matters because authority without administration creates liability, and structure without governance creates confusion. So where do we go from here? We move from understanding systems to building structure. We move from learning concepts to documenting decisions. We move from theories to administration, and we move from reacting to governing. The literacy series ends here, not because there is nothing left to learn, but because the next phase is no longer about myths, systems, or explanations. It's about administration, governance, responsibility, and structure. If the literacy series taught you how to recognize what does not work, the next phase will teach you how administration actually does work, slowly, deliberately, and with records that support every decision made over time. That is where we go from here. So join us for our next group of classes starting April 7th, 2026 at 5 p.m. Pacific Standard Time. This is on the Private Path HR Solutions PMA website, and it is for members only. It's an educational series, so if you wish to partake in this series, please do sign up as a member and we will get you signed on. Have a great night. Okay, we are done. Woohoo! Let me stop this recording.